Hey guys, and welcome to today's video. Today we've got a sovereign citizen whose hopes, dreams, and whatever is left of his critical thinking get absolutely obliterated by a tag team combo of a judge and a prosecutor. It's a beautiful thing to watch, so let's jump right in.
All right, the court will call the case of the state of Michigan versus Eric Martin, case number 23S00425.
Rachel McDuffie for the people.
And standby counsel, Assistant Public Defender Jay Bellinger from Mr. Eric Martin, who appears via Zoom. Mr. Martin, can you please unmute and state your name for the record?
I'm a living man, capital E, lowercase R-I-C, of the capital M, lowercase A-R-T-I-N family. One of the people, sovereign, not a legal fiction corporate entity defendant with a name similar to mine. I'm here by special appearance to threaten duress, not willingly. Now, again, I object again to any attorney being appointed to me, representing me. But that's something I want to ask you, Washington. Now, you said you're appointing this public defender. Are you appointing it for me, or are you appointing it for you? Or is it
So
just standby?
I made my decision on that. It's standby counsel. If you have motions to make, you need to make those at this time.
Yeah, that's I need. I'm seeking clarification. Are you appointing him against my will to have an attorney appointed for me?
Yes, it's not representing you. He's standby counsel. Please make your motions.
Okay, that's it. Well, that's I was going to make the motion to dismiss him if he's if you're trying to appoint him for me, which, as I already said before, I will not be taking no attorneys. I'm one of the people. I'm not a defendant who's, yeah. So as I said before, so I'm not going to be accepting any attorneys.
Nobody's telling you that you have to accept the attorney, but the judge is doing exactly what she's required to do, protecting your constitutional rights by appointing standby counsel. Just in case, at some point, you suddenly realize how wildly out of your depth you actually are.
And which would then fraudulently give the presumption I'm under the jurisdiction of the court, which I'm not. As I said before.
Sir, you got 5 minutes to make your arguments, and you can spend them however you want to.
All right, yeah. Like I said before, I'm a living man. So as the U.S. Supreme Court said in the cases I cited to you before, there's no jurisdiction over a living man. Corporations don't have jurisdiction over a living man without our consent. I don't consent. And it's also under, there's no consent under the Declaration of Independence of 1776. There's no jurisdiction over a human without their consent. So I never consented to jurisdiction, and I don't now, and I never will. Now I have some questions, though, for the prosecutor. That's
Sir, you don't get to ask questions. If you want to have a motion, you can make those.
Well, I object to that. That violates my right to a due process. It's relevant to a standing argument as to the prosecutor, whether they have standing or not. I think that's relevant to move forward or not, you know. There's no standing, shouldn't move forward, but. So what's your ruling on that?
Your motion is denied as to jurisdiction and standing. Now, do you have any additional motions?
I object to that because you didn't allow me to answer the questions to see whether you had a legit basis to make that ruling.
Your objection is noted.
Judge Washington is not messing around with this idiot. She doesn't have the time or the patience for his games, and honestly, her hair looks way too good today to be dealing with this level of stupidity.
So you're going to be questioning me about the some demands I made to dismiss the case anyway, right?
I'm sorry, what?
You said you're going to be addressing some demands for dismissal I made or sent to you already. You're going to
First of all, a demand is not a proper format before a court and could be dismissed outright. However, I'm going to allow you to make your motions here. If you want to make an argument, you can do that, sir.
I object to that. That's not true. As I mentioned before, demands, when someone has the right to something, that's what the terminology demand is made. And that's the only reason why I make it. Motions, even though I know that's all you see in the court rules or whatever, traditional. But that's for a request. And persons are not, or humans are not supposed to be requesting constitutional rights. You know, me exercising my unalienable human rights and constitutional rights, I'm supposed to be making demands. That's how I've been, and that's backed up by law. And that's how I've been taught. And so that's what, so it's all right and proper. Motions are requests, you know. And the defendant makes motions also, since I'm
So you're
disputing.
about the end of your 5 minutes.
Well, I objected 5 minutes being any time limit also. That violates.
I don't care about what you're objecting to. You can make it on the record. It is noted. Now, if you have something that you want me to address, you should do that before your time is up.
Putting a limit on my First Amendment right, that's unconstitutional.
Sir, please, if you want to have something to say, other than the circular talk that you're doing, you should probably do that at this time.
I didn't finish. That's why I didn't mean none circular. I didn't finish the first time. All right, well, that's it. As to that,
Is the court ready for the people's response, Your Honor?
I don't know if he's done with his motion.
Oh, I'm sorry.
I'm trying to make.
Well, the police, I want to question the police officer who wrote the ticket. I have a relevant question to him as to self-incrimination, move to dismiss the case based on that, because he made me give, my ID.
I thought you dick flutes didn't believe the police had jurisdiction over you. So if he supposedly has no more authority than some random guy like me, then explain how it's impossible for him to make you hand over your ID under threat any more than I could. Your logic collapses under the weight of its own stupidity.
But my memory was a little, I don't really remember exactly what was said. That's why I kind of need to question him to refresh the memory. But I do remember in general, though, he kind of, I'm required to give my ID if I remember right, and I might have been arrested if I didn't give my ID, which is under threat and duress. And even if he didn't say that, which I don't remember, which, like I said, I need to have his body cam and all that. I want that. I want to be able to review that now, and also for the trial, if this goes to trial, I want the video present as part of my due process right for the evidence, which is my due process right, like I'm saying. And because, like I said, it violates my self-incrimination right, that I'm being made to give my supposed name, government name anyways, which ain't really my name, but a government name has been given, violates self-incrimination. And then it's used against me to prosecute. So it violates self-incrimination. Yeah. Move to dismiss based on that too. And like I said, if you need more evidence as to, like I said, his questions, then he needs to answer my question. I was about to send out interrogatories to him. I'm about to do it here soon. If you find that's necessary, unless you find it ain't necessary, I'm gonna send it out soon. So, another thing. Now, Mrs. Washington, I just filed a federal civil lawsuit on you, for violating my constitutional rights during this case. So you may want to consider recusing yourself. I know you probably didn't get a receipt yet because I just sent it out like 2 days ago. So the court will be getting it, if they didn't get it already, be getting it this week. And yeah, so I want that out.
As to your motion to recuse, that is denied.
Because you're a crayon-munching dumbass, that's why. You haven't presented a single argument that would justify the judge recusing herself. Just like with a public defender, you're free to ask for a new one, but that doesn't mean you're going to get one.
I didn't mention that, but I thought you might kind of already figure that. But conflict of interest due to the lawsuit being filed, that's the grounds of my demand for dismissal.
Okay.
And I would like to, Ms. Duffy, as the prosecutor, I'd like to notify you, of the crimes being committed against me by the police officer, in this case, writing the tickets, and I request you prosecute them for this, because I'm the crime victim here in reality. Because I was traveling by right, which the U.S. Supreme Court said we have, as long as you're not carrying passengers probably for profit, you're not technically driving a motor vehicle. Therefore, all these charges are baseless. There's no case here. So in reality, I was harassed, retaliated against for exercising my right to travel on my motorcycle, you know, and then with these charges. Okay, so because they had no evidence that I was carrying passenger property for profit, which is what's required. That's the definition of a motor vehicle under 18 USC section 31 subsection 6 and 10. That's when a motor vehicle is a motor vehicle. In contrast to the state law, I know what the state law says. The state law just says, oh, if something's mechanically drawn, it's a motor vehicle. Well, the state statute is in violation of this federal statute. Therefore, it's unconstitutional. Okay, and therefore, the federal statute definition of motor vehicle applies here. It overrides the state statute under Article 6 of the U.S. Constitution. Laws of the United States is supreme over state law. So therefore, I wasn't doing anything wrong. I was traveling by right on my motorcycle, as I have a right to do, without a license, without registration, without insurance.
Well, no need to even bother trying him on those 3 charges. He just admitted his guilt on the record. Case closed, gift wrapped, and hand-delivered by the defendant himself.
So I was all within my right under that federal statute and the U.S. Supreme Court case law that I cited already in the court that they sent back. But one of the main cases here is Packard versus Banton, U.S. Supreme Court case law. Okay, this is a little more specific than just saying people have a right to travel. It mentions here specifically, and I'm going to mention right here, Volume 44, Supreme Court Reporter, page 259. The streets belong to the public and are primarily for the use of the public in the ordinary way. Their use for the purposes of gain is special and extraordinary, and generally at least may be prohibited or conditioned as the legislator deems proper. As they're saying right there, so we do not need a license if we're not using the streets for profit, for gain. I wasn't doing that. The police don't have no evidence of that. So he shouldn't even pulled me over, stopped and wrote a ticket, none of that. So I'm the crime victim. I request you prosecute him for that. And it's also a federal crime, which I'm going to be contacting the FBI about. I already tried once. I got to call him back.
Well, unfortunately for you, you're not in a public environment. You're in a courtroom. And even though this is happening over Zoom, the same rules and procedures apply exactly as they would if you were standing there in person. Now let's turn things over to the prosecutor, who is about to absolutely dismantle everything this guy believes in.
Well, I'm going to see if you got my, if you're going to, I would like to just reiterate my, the demands for dismissal already made, or if you want to call them motions, but like I said, I like using the word demand because I want to, I don't agree to no unlawful presumptions that, because I understand the legalese a little bit where you say one word and it means something else and it's presumed. And that's why I demand also that there be no legalese used in no stages of this case, because that's one of the fraudulent things going on in the court system. I'm going to be filing a class action to stop this on a grand scale, but I know it's happening. That's why, like, for example, I use the word demand to use the word motion, and it can be presumed you're a defendant. Because defendants make motions, see? So that's why there should be no legalese used here. It's fraudulent, it's wrong, it's immoral, it's pathetic. Whoever made this stuff, because it's putting it's a blanket on a lot of people. They don't know no better in the system. Something else. Now, when this proceeding started, I noticed on the screen it said no recordings are allowed. Okay, now I object to that, in that violates my due process right to preserve evidence, me or anyone else, and I'm not just speaking for me, I speak for everyone else. All the people have a right to record in any public court. This is all public. The U.S. Supreme Court already said this. People have the First Amendment right to record in public anywhere. And it's also a due process right to preserve evidence. Because if my rights are violated during these proceedings or any other, along with anyone else's, we have the right to record that and have that evidence to bring criminal or civil charges. So that's why that's not supposed to be popping up on the screen that video, audio recordings ain't allowed.
Man, he picked a fight with the wrong one today. This is easily one of my favorite sovereign citizen shutdowns of all time. And just to rub salt in the wound, she tops it off with a classy little reminder that he's not even playing the same sport, let alone competing in the same league.
Thank you, Your Honor. So I am aware of 5 items that have been filed by Mr. Martin, I think after this case began to be pending in this court. And I'll just briefly address the as to the formatting of those. I did notice all of them are handwritten. He does write a date on the top of each document, but then he usually signs off with a different date on the bottom of the document. So if it ever comes into play that there's an issue with the timing with respect to deadlines or anything like that, for my purposes, I'm just going by the date that it was received by the court, which is usually a third date that is different from the other 2. So the first document I'm aware of is titled Demand for the Return of My Motorcycle. That one was received by the court July 27th, or yes, I believe somewhere around there. I'm sorry, I'm not going to the dates aren't really important, so I'm not going to dwell on those. I'm just addressing these versus actually, I think, responding to them in detail. Defendant specifically ordered and demanded that the troopers from Michigan State Police return his motorcycle in this case. That is a request to police that was filed with the court. No response appears to be required or called for from the people, so I don't have anything to say about that. Next is the motion that was filed for the disqualification of the judge in this case. And I just wanted to point out a couple of things. First and foremost, as Mr. Martin pointed out, the court rule that relates to disqualification of judges, MCR 2.003, speaks to the exact procedure for that. In a single judge court, and actually the challenge judge here is the chief judge, the challenge judge is the person who decides this motion. So I don't have any argument to make as far as that, but I would point out there is a quote included in that particular motion that challenges this court's jurisdiction. And it cites a case from, what's that? Oh yes, Penhallow versus Domes Administrators. That's a case from 1795. And the specific quote that was cited in that case to challenge this court's jurisdiction, it's a paragraph or so. It begins with something about, heavens, let me see. I want to make sure I have it correctly. It's not really important. In as much as every government is an artificial person, a creature of the mind only, all that stuff about artificial persons. I think Mr. Martin already made some references to that. I just want to make sure that Mr. Martin is aware that specific quote does not exist in that case whatsoever.
I love when they try to cite actual case law. It makes it so much easier to point out their dumb nonsense. And what do you know? He picks a case I can recite from memory thanks to every other SOVCIT who's tried the exact same stunt in court. Murdoch v.
That quote that he used to challenge this court's jurisdiction doesn't exist anywhere at all, except for other cases where sovereign citizens have copied and pasted that non-existent case law, and they've been told the same by other courts. So apparently there's like a bank of things to be shared amongst people making this argument, just so he knows and everybody else out there knows. That does not exist. It's not a thing. It's nowhere in that case. That full text of that case can be Googled for free. You will not find that quote. The same is true of another case he cited, Keller versus Potomac Electric Power. That's from 1923. That case also does not include that quote, those words, or anything even slightly resembling that argument regarding the power he believes is lacking here due to municipal court status. But FYI, the Michigan District Court Act of 1968 did abolish most of the municipal courts. 4 of them are left that they did allow to remain: Grosse Pointe Farms, Grosse Pointe Park, and Grosse Pointe Woods. All of those are in Wayne County. We're in Washtenaw. So just so that Mr. Martin is aware, this is not a municipal court. It's a district court. Finally, as to the motion to disqualify, as I mentioned, that is for the judge to decide. But I might want to point out the manner in which he chooses to pursue that disqualification, including any comments or insults. For example, on page 9 of his motion, when he says that also Washington is not a real judge, but a clerk masquerading as a judge. Pursuing disqualification or recusal, or even a federal lawsuit, does not insulate you from the contempt powers of that very same court, should you choose to continue escalating that type of behavior. That's just the more you know from me. Third, next document that was filed from this court, it's titled Martin versus Mike. Plaintiff's response and response and objections to my return criminal complaint on Mike and the attached court letter that vaguely, unfairly stated filings does not comply with MCR 6.101 and 6.102. I didn't have a letter attached to that to refer to, but it looks like that is the court's rejection of an improper filing or format. I honestly have no idea who Mike is, but the people of the state of Michigan are not listed as a party in that filing, so I don't really have any response to that either. I can advise, though, that Mr. Martin mentioned earlier, and it's stated here, that the reference to this criminal complaint, because a defendant refers to himself as a plaintiff and title something as a criminal complaint, it doesn't make either of those things true. So I'll direct Mr. Martin to the same court rule he actually cited in that filing, which is MCR 6.101. The prosecutor's approval or posting of security. A complaint may not be filed without a prosecutor's written approval endorsed on the complaint or attached to it, or unless security for cost is filed with the court. I just wanted to disabuse him of that notion that because he creates a criminal case, I guess in his mind and on paper, it doesn't mean that that exists in reality.
Got him.
So nothing more from that. The court's rejection of an improper filing really isn't my business. So no response from opposing counsel would apply today. The last two things that were filed before the court are two demands. The court has already mentioned demands. I'm so sorry. It's a lot of talking happening here. I gotta refresh. Two demands. One demand for default judgment and another demand for summary judgment. Both of these I would have the same reaction to. The demand for summary judgment, summary disposition concerns parties to a civil action, and defendant is referring to civil procedure, not criminal procedure. There is no summary anything of that notion in criminal matters. Now, he made some references to Article 3 of the US Constitution. That pertains to federal courts, appointment, tenure, Supreme Court justices, federal circuit and district judges. Those are Article 3 judges. Those are the ones nominated by the president, confirmed by the US Senate. So this court is not controlled by Article 3 of the US Constitution. But I think he knows that because he's citing Michigan court rules to sustain his argument for pretty much everything else. So that doesn't change here. Summary judgment is not a thing here. Default judgment. Now, that's not quite the way it works. I think he argued that because the prosecutor in court did not respond to the request to return his motorcycle for that first filing that I mentioned, that he should have a default judgment and he should automatically get what he's demanding because he didn't respond to it. Well, I'm responding right now, but that's not how it works either. Again, this is kind of a civil issue. There are cases where there are default judgments filed, but those are civil actions. We have traffic tickets that defendants fail to appear and get a default judgment. But if that were the case, I would have a default judgment of conviction for every criminal case where defendants fail to appear. People are on bench warrant status for 6 to 20 years at a time. I don't get automatic default convictions. So again, that's really not what's happening here. So those are the 5 things that I'm aware of. Now, finally, if it were true that, as Mr. Martin stated, that federal law trumps all state law, and that all state law and state courts are unconstitutional, the state court system would not exist, and the US Supreme Court would not hear cases resulting from the need to interpret state law. Mr. Martin has yet to hear, as all of us do, of state constitutions and the power of the state courts that come from those being abolished. So his reference was correct, that there are people in this system who don't know any better and don't know what they're doing. I don't think present company is excluded from that.
Pennsylvania was not a right-to-travel case. That IT was a First Amendment case involving religious door-to-door salesmen who were required to obtain a license to sell religious materials. That if the materials hadn't been religious, the licensing requirement would have been perfectly fine. But because the products were religious in nature,